This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're talking about mom in the law. We're talking about the tough part of families, and that is family law, divorce, child custody. When moms and dads can't agree, what happens? What about after the divorce? What about getting a modification to the orders? Or if they never got married, how do you go about getting a custody order? Call in your questions about family law. 256-536-0077 is the 31 Law Call number. We're also going to talk about trespassing children. This time of year, well, kids are about to get out of school. If a child wanders into your yard and gets in your pool or into your building, your construction materials, and gets hurt, are you in trouble for that? We also always invite you to send in your email questions. You can send them any day of the week on any legal topic. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we will have some of your questions. We have some of those tonight about family law issues. We've got Michael Timberlake with us from Senior Timberlake and Lee. Good to have you here tonight.
Well, it's great to hear.
And we are going to have Amber James is standing by. She's going to zoom in with us tonight to talk about family law. Hi, Amber. Thank you for being with us, staying up late tonight.
Thank you for having me.
We'll be right back to Amber. We'll get to family law questions in a minute. Michael's going to walk us through, okay, a child trespasses on my property and gets hurt on my property. Am I in trouble over that? Is my insurance going to get hit, or am I going to get sued over that?
Yeah, I mean, it's a big, concern that people have when they are dealing with people that come onto their property. In general, you don't have an obligation or a duty to a trespasser. So if somebody comes onto your property without your permission, or somebody that you don't know is coming onto your property at any given time, or there are signs in place that say do not trespass, then those people you don't have a duty to keep your property safe for a trespasser. Now, if you know people are coming on, or if you set a trap, you can be in trouble for a trespasser. But in general, you don't have an obligation. But if you have something on your property that you know, or you should have known, that other people would want to come look at, children in particular, that, a pool, a playground, some kind of, skateboard park, something going on like that, that is an attractive nuisance, that children will want to come onto your property, you knew or should have known about that, then you can potentially be held liable if they're injured on your property.
We got summertime coming up, and kids are going to be coming, so be watching.
So, like I said, it's all great. Don't set up a snow cone factory on your property.
We're taking your calls and questions tonight about family, divorce, child custody, child support, alimony, all of those questions. And Amber James joins us from New Beginnings Family Law. She's here in Huntsville, and she specializes in family law. We come up against each other from time to time with cases, but it's good to have you here tonight. Welcome.
Thank you so much for having me on the show. I really appreciate it.
And thanks for doing it by Zoom so we can socially distance. You've been on the show numerous times in the studio. I was trying to think what new cases have come up, new things, changes to the law, or things to tell people to be watching for. One of the things that started to come out, there was a case that came out talking about the morality clause. In divorces, they usually here in Madison County put in a rule that says no overnight boyfriend-girlfriend. Once the divorce is over, mom can't have her boyfriend spend the night when the kids are there, dad can't have girlfriend spend the night, or romantic interest of whatever type. That may be on its way out. Amber, talk about that a little bit.
Sure. Our Court of Civil Appeals has entered an opinion, basically. When you don't like what you get at the trial court, you can appeal that up to the next level, and they have said that basically, unless there's some sort of testimony or evidence that the boyfriend or girlfriend is harmful to the child, that you really just can't blanket keep boyfriends and girlfriends from spending the night with children. It's still in our parenting clauses here in Madison County. So for right now, I think we all have to advise our clients to still follow that. But if it goes up on appeal, it could very well, go away.
And I know we've had clients all along that would say, why can they put something like that in there? Or do I have to? What if my ex says it's okay, but the judges put that rule in there and they can get you for it? Any other big changes that you feel like people ought to hear about, or we can talk about child support and how that kind of thing gets calculated, the basics people always want to know?
Sure. I don't think there's been anything else too big. I know there are several things that the legislature is considering at this time regarding changes to the custody language and the words we use to define custody. So I'm really interested to see if that passes, and if we all get to take all of our former agreements and now have to change all the wording and relearn new terms.
Seems like it happens when the judges go to conference. They come back with some new plan they put us under.
Well, you know, the appellate courts
exactly.
get to reinterpret what everything means, right?
Yes, they get it
Right.
and they say, oh,
Right.
we didn't mean that, or somebody new gets
Well,
elected
we
in there.
can
and they
just change it.
We just change it. Let's talk a little
Yeah.
bit about how family law affects what you do. So if parents are divorced or was a child that was not born of a wedlock and a car accident case takes place, Michael, how does that affect the lawsuit that gets brought, or does it?
Well, I mean, it can affect it in the essence of, you know, who gets to bring the lawsuit. You know, obviously the best thing that we want to do is cooperate with both the mother and the father of the child and make sure that they understand what we're doing for the child, and that everything that we're going to do is going to benefit the child and not necessarily the parent. The parent does have the ability to get paid back for medical obligations or medical bills that they have paid. But in general, any money that is recovered in a personal injury situation is going to go to benefit the child. The law does say that the custodial parent has the right to make that claim typically. If it's for the death of a child,
Yeah.
the custodial parent has the right to make the claim. Otherwise, either parent could make the claim for the child. But again, the money is going to go to the child, so the parents need to really cooperate together to make sure that it benefits the kid.
Our law call number to call in a question, 256-536-0077. Amber, talk a little bit about child support. How do judges come up with a child support number, whether it's married parents or unmarried parents, and does that make a difference?
Actually, it doesn't make a difference whether they're married or unmarried, but child support is calculated according to what we call Rule 32, which is Rule 32 of the Alabama Rules of Judicial Administration. And so we take mom's income and dad's income, and we need to know how much they're paying for health insurance premiums or any daycare expenses they may have. And all those numbers go into a formula, and we have a chart that we use that helps us determine child support. It gets a little more hairy when parents are going to share custody, because not all of the judges calculate child support in the same way when we're dealing with a joint custody situation.
Okay, we got this email question in from Angie. Angie says, how old does a child need to be before he can choose which parent to live with? Amber, we hear this on a daily basis, don't we?
Yes, ma'am. At least once a week I get that question.
What's the answer?
When they're 19, when they're adults,
when they get to make their own decisions and figure out where they want to pay rent.
Yeah, age
True,
of 19
exactly.
is the age of majority in Alabama, and we do from time to time have children come in. We call them as witnesses, and they testify. Judges don't necessarily like it, but if a child comes in and talks, Amber, talk a little bit about what a child could testify to and how a judge might apply that.
Sure. A child can testify in a variety of different ways. Normally, we ask that the parents leave the courtroom when their child is testifying so that the child doesn't have to look at mom and dad while they're telling what they need to tell the judge. And then the judge can take into account the age and maturity of the child, as well as the other testimony that the judge hears, and make a decision about whether or not the child's opinion about where he or she wants to live is going to be considered valid. I've tried cases where the child's testified and the court has found the child's testimony to not be valid because the child's been alienated from the other parent. But I've also had it where a child has testified in court and the court has taken that into consideration in making a decision regarding custody. So it gets handled in a variety of ways. It just depends on, like I said, the age and maturity of the child, as well as the other testimony and evidence presented to the court.
How about, we got this email question in from Bethany. Bethany says, if your ex lives in another state and isn't paying child support, where do you file a complaint? In your home state or in his? Where do you file something like that?
Sure. I always advise a client in that situation to contact their local Department of Human Resources. They have a child support enforcement division, and they can work with that division in order to establish child support. They will, DHR will then take that petition generally and file it in the court where the parent, the obligor parent resides, so that the custodial parent doesn't have to travel back and forth, but they can take all the steps they need to enforce any child support orders that might be entered.
And typically it would need to be handled in the same state, right? It's got to get to the state where the original order came from, unless there's been
Sure.
long departure. Let's take a little break. We'll
Sure.
be right back answering more questions all about mom and the law. We're talking about family law tonight. Stay with us.
celebrating 25 years of serving the Tennessee Valley. This is WAAY 31 Law Call, with guidance from the Huntsville personal injury firm of Sinyard, Timberlake & League, devoted to helping victims of truck and car wrecks, medical malpractice, dangerous products, and wrongful death. With founding attorney Tommy Sinyard, helping injured Alabamians for more than 40 years. Attorney Michael Timberlake, managing partner and top-rated by fellow lawyers for legal ability and ethics. Attorney Will League, experienced in trying and winning cases across the state of Alabama. Hosted by award-winning broadcaster and practicing family law attorney Sharon Doviet. And guests from across the Tennessee Valley. Your rights, your calls, live. WAAY 31 Law Call.
Welcome back. I'm Sharon Doviet. Tonight we're talking about mom and the law, so we're talking about family law, everything from divorce to child support. And we've got with us Michael Timberlake from Sinyard, Timberlake & League here in the studio, and Amber James, who is with New Beginnings Family Law in Huntsville, but she'll take a case all over North Alabama to help people out. Amber, we've got, people will ask us many times, if I don't like the order, so it's an old order, it came out a couple of years ago, it's not working anymore, what do I do to change it?
Well, you can file a petition to modify, but I normally would ask a client, had they had the opportunity to talk to the other parent and discuss what changes may be able to be agreed upon by both parties before they involve the court.
Saves a lot of legal fees to try. You can at least try, right?
But
you can at least
can the
try,
parents
yeah.
just agree to just do what they want to do in terms of visitation, child support, whatever? I mean,
Definitely.
If they just do that without involving the court,
the court doesn't have a microscope or a magnifying glass. They're not watching you, so
Right.
they'll never know if you don't
Right.
bring a case and sue the other one for contempt or whatever. Visitation, definitely. If you've got a different plan, the court doesn't care how you carry out your visitation schedule. If you agree on it, do whatever you want to. The visitation schedule is just at a point where we're no longer in agreement, then this is the standard. This is what we're going to follow, and this is what we're going to go by. Other things, child support, you may be in a lot of hurt. Amber, if you stop paying child support and she seems to be okay with it, right? Or he?
No, that you definitely need to get that order amended if you're going to change how the child support is going to be paid, because that could really, you could end up in a pickle later on.
They may come back looking for that money they said they didn't need.
Yes.
Plus interest.
Exactly.
Plus interest, that's right. We've got Debbie on the line with a question from Huntsville. Hi, Debbie, thanks for calling. What's your question tonight?
Hello. My question is about...
Yes, ma'am. Debbie, just listen through your phone. There'll be a delay if you're trying to watch TV. Listen through your phone. What's your question tonight? Uh-oh, I think we've lost Debbie. We'll try and get her back. Let's talk a little bit about a way that family law cases can affect your personal injury cases. Michael, if there is this big amount owed for child support arrearage, and somebody's got a personal injury case, they've got a car accident case, can the person who's owed that money come and intervene in your case?
Yeah, I mean, absolutely. What we see in situations where there's somebody's injured, one spouse is injured, and they've got a child support obligation. It's a back child support obligation. That can be garnished. The claim for personal injury can be garnished. Which means that they have the right to be paid before there's any money paid to the injured party in the case, because they have a back child support obligation. It's kind of in any situation where there's a judgment entered, you have the right to interfere with another claim. But in a child support situation, the state DHR has a very, very priority type claim that has to be dealt with in these situations. So we've gotten great settlements for clients that have really benefited their children as opposed to the client.
That's a hard conversation.
It is a hard conversation.
We've got Pam on the line with a question from Hazel Green. Hi, Pam. Thanks for calling. What's your question tonight?
So I'm taking my ex-husband back to court to pay medical bills. He's not been willing to pay any of the medical bills for over a year now.
Okay.
We've got up to about $9,000, and he's supposed to pay half, and he won't contact me. He won't respond in any way. And so I've filed a petition of contempt based on our order. And I know that he has 30 days once he was served. But what I want to know is, am I going to be in trouble not going to an attorney because I really can't afford an attorney right now. So I want to know if I have to have an attorney just to give me good support, or is this something that's just going to be kind of automatic?
You can be pro se. It's hard.
This is a cut and dry situation, but there can be things that can come up.
There can be things. Amber, what are your thoughts on something like this?
I think that, you can definitely try to do it on your own. I think this is another situation where you may be able to get help from your local Department of Human Resources, because they're there to make sure children receive the support that they are due. But if you decide to go it alone, you need to be very, very organized. You need to have all your bills printed out and marked, and maybe even added up on a spreadsheet to be able to present to the court.
It's also the case that when if the other side is in contempt, the judge could award legal fees. So the very thing that you are avoiding having to spend money on, and we get it, it can add up. But it could be that the judge would wind up awarding you not just the $9,000 or half of the $9,000, I forget which it was, but also legal fees on top of it. So you could always go talk to a lawyer, meet with a lawyer, and see what their thoughts are on it. Another thing with medical expenses, a lot of the orders will say that if you didn't tell them within 30 days of incurring the expense, you can't claim it anymore. So read your order. You probably have it. Be very clear of what you're talking about, and get your proof of when you gave him notice of those bills as well. We got this email question in from Jason. Jason said, my ex-wife is planning to move to another state with our kids. Do I have a say in this? It's going to keep me from seeing my kids every other week like we agreed when we got divorced. Amber, what are your thoughts on this one?
Well, he needs to make sure that he goes back and rereads his order about the Alabama Parent-Child Relationship Protection Act, and make sure that she complies with that. She may have told you right now that she's planning to relocate, but she needs to send you a letter by certified mail 45 days in advance of her intent to relocate. And once you receive that letter, now you only have 30 days to file a petition with the court to try to prevent that move. And I know so many people will read that and think that I just need to send her an email or a text message and tell her I object, but you actually have to file a petition with the court, and then the court's going to decide whether or not she can relocate or not.
Would you tell him to wait for that certified letter, or if he knows she's planning on moving, should he go ahead and file something?
Sure. I think that's a tough question that you really depends on the circuit that you're trying your case in. Some judges don't want you to kind of put the cart before the horse, and of course if she relocates and doesn't send you that letter, then that is a mark against her. It's one of those reasons why the court could reverse custody or give you custody rather than you guys sharing custody, because she failed to give you the appropriate notice. So it's one of those kind of really hairy situations where you really need to know your court and your judges and how they're going to handle whether or not that's considered something that you should have filed. Well, it's not that you should have filed, but whether you should go ahead and kind of jump ahead of her sending you the notice, or jump ahead of her relocating without sending you a notice.
Good.
Because it could be that then she decides, well, I'll just hang out here now that you filed. So
now that you said so.
Right.
We've got Debbie back. Debbie's on the line with a question from Huntsville. Hi, Debbie. Thanks for calling. What's your question tonight?
I kind of got confused because I got dropped, so I hope I can remember to.
That's okay. Welcome back.
In a sensible way, anyway.
Yeah.
And I think it has maybe to do with the Freedom of Information Act, possibly.
Okay.
Maybe you can tell me that. I'm helping a friend who has been trying to go back and collect some information from when he was a child. He was adopted, and then he was incarcerated as an 11-year-old. And we went back to the state, and the state started sending some documents, because they said there were a lot of documents. They would only send 100 at a time. So we got the first 100, and the things we were looking for. And then this last week on Tuesday, the lady called and she said, we can no longer send you any more information. To get anything, you must contact your adoptive mother and get her permission, and she can then allow you to have this information. And it seems very strange that he is a 40-year-old man and he cannot get any information about when he was incarcerated as a child, and that she would have still control over this information. It just doesn't make sense. And I'm just wondering if there's something funny going on, or could that possibly be the truth?
Interesting. I have not had anything quite like that.
That's an incredibly fact-specific situation. It's not something that we probably deal with on a regular basis in terms of, that type of information. Obviously, the state departments that regulate this, they will give you a written answer, and you can ask for a written response to a question that you may have about why they won't provide that information. So that's kind of what I would encourage you to do. It's a little more, it's very fact specific, so it's a little more than we can handle here on the show, I think.
Amber, have you had anything quite like that?
No, that's a new one for me as well. I would just refer her to it's 2610A of the Alabama Code talks about adoption and how you can obtain documents. So I agree with what Michael said. Call this, contact the state agency in writing and see if they will give you a response about why they're not allowing you that information. But if you could, talk about those code sections and quote those in your letter to the state agency, I think that would be helpful as well.
That's good. Let's take a break. We'll be right back answering more of your questions about family law. Stay with us. If you didn't get your questions answered tonight, we're going to tell you how to reach Amber James in just a minute. Next week, May the 16th, insurance company secrets. Oh, you want to know those. May 23rd, it's all about crime and punishment. And on May the 30th, we'll talk about going to trial. If you didn't get your questions answered tonight, here's how to get in touch with Amber James. She is with New Beginnings Family Law in Huntsville, 256-596-8373. Also check out newbeginningsfamilylaw.com. Here's how to get in touch with Michael Timberlake with Senior Timberlake and League. They are personal injury attorneys. So everything from car crashes to nursing home negligence, call them 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way. And I practice family law too, 256-539-7337. Thank you for all your calls and questions. Amber, thank you for staying up with us and zooming in. Have a great week.
Thank you so much.
See you at the courthouse.
You too. Yes, ma'am. All right, bye-bye.